Chief Justice, Dr. Flavian Zeja, he always asks me to assure Ugandans that the judiciary is committed to ensuring that we perform our mandate as under Article 126. You know, judicial power is derived from the people. We are servants of the people. We administer justice. We ensure that the rule of law is protected, human rights and freedoms of persons, and then we contribute to economic development. That is the full package of the institution of the judiciary. We don't work in isolation. We work with other organs of government. We work with other arms of government, agencies, ministries, so that we can holistically deliver service to the people of Uganda. Yes. Right.
Now let's look into, I know one thing for sure is that there are conversations that are of very good interest to the public, and we might as well completely break this ice, starting off from that perspective. Looking at bail-related cases in the recent times, Kiza Besije, Elias Lukwago, Chris Obore, all of these are bail cases that are trending.
Yes.
And what we see in most of them as a common factor is that bail has been asked and denied. So one wonders, we're all told every day that bail is our right as a Ugandan. But at what point are we denied bail, and at what point are we allowed to enjoy our right of bail?
Thank you so much for that question. I want first of all to correct the narrative. Bail is not a right.
Okay.
What is a right under the law is the right to apply for bail. And the moment there is an aspect of application, then one should expect two things. One, the application to be granted, meaning you have satisfied the conditions that would ordinarily allow you to be granted that bail. Or two, you have not satisfied those conditions, that then the judicial officer will deny you the bail. The whole essence is not denying you, but the discretionary powers of a judicial officer, when they are listening to this application, allows them to cast wide and broadly to appreciate the applicant, the circumstances of the case, how sensitive it is, how it impacts on community, society, including the effects on the person himself, and then the law, and then whether he will interfere or he will be a flight risk, and then the court decides based on that judicious discretion that the person be granted or the person is not granted bail. And if you are not granted bail, that's not the end in itself. That's why you have seen subsequent applications for bail. Circumstances may change. And when circumstances change, you might again make your application to the court, and the court might again go ahead and release you. But if they don't change, still the court may insist and may not grant you the bail. So applying for bail is what our law provides for, but not that persons have a right to bail. That narrative has continuously eluded many, and it's very, very sad sometimes when even land people who have, I would say, elites, keep saying that yes, he has a right to bail, he has a right to bail. He has a right to apply for bail, because this is a matter before court. There are so many aspects of trial, there are so many issues involved, and so discretion comes into play, and it must be judicious. So when somebody is denied bail, for starters, bail, you can appeal to the next level if you think this person has any other reasons why they have denied you bail. So you can apply the next step. If it's a magistrate's court, you apply to the chief magistrate. Okay? If it is a chief magistrate who has denied you the bail and you think he did not give it to you judicially, you can apply for that bail in the next court. If it's a capital matter, you have seen many people applying for bail several times. Okay, that is what is provided in the law. And as long as we follow the rule of law, Ugandans, you should find some of these things very easy and very comprehensible.
I believe you are today years old and you are learning that the right you have is to the application of bail, not necessarily bail in itself. This is why we learn, unlearn and relearn when we have conversations such as this. 0709602592. Share your WhatsApp message via, share your question, opinion as well via WhatsApp to that number, and let's engage and discuss this topic as we are indeed, like I always say and I've just said, learning, unlearning and relearning. Let's also educate us on what the difference is between bail and bond.
And bond. Oh, thank you. Before I go to bail or bond,
right,
I want to put in a context. You see, Ugandans need to learn from certain examples.
Right.
And I want to speak to that person who thinks when a court denies them bail, then the court is not doing the right thing. Perhaps. But look at the situation. We have had instances where judicial officers have had applications for bail in capital cases. And I will give you one sad story where a person was charged with the offense of manslaughter. It was just manslaughter, okay? And manslaughter is trial in the magistrates' courts by a chief magistrate. Now this person apparently applied for bail, and the judicial officer, considering the circumstances of the case, did not find it fit to release this person on bail given the circumstances of the case. The narrative we got on social media and the other commentaries was that these magistrates don't understand the law on bail. For one reason, that this is not capital in nature. This is just a manslaughter. Why would you deny somebody bail? Then, of course, the usual statement, it is his right to bail, it's his right to bail. But I want to educate our Ugandans.
Others will say that
of course, that narrative has also continuously been there. But our role is to change that narrative,
right,
to educate the Ugandans to understand why this person was not granted bail. But I will tell you, when the court finally succumbs to those kind of unnecessary pressures, for which I personally think are improper, a court of law should never succumb to pressures, because the judicial code of conduct one you took is without fear or favor. You shall administer justice. But I will tell you this, the court, on a second application, the court went ahead and granted bail to this other person. Do you know what happened? Our Ugandans who have chosen to take the law into their hands, when this person was granted bail, which society was claiming for and clamoring, this gentleman did not see the chance to return to court because he was lynched. Now you can see that balance. The court, viewing and appreciating the circumstances of the case, felt it was not safe for this accused person to be released on bail because the community was hostile. You understand? So the court chose to hold the application and denied it at that point, and gave those reasons. When our people don't understand some of these things, even when reasons are given, they are then released. But this person was killed by the mob under such circumstances because the community was still very furious, and at the end of the day we had no case to try. There was no accused person to try. Why? Because when he was granted bail, the community which was injured by that crime took the law into their own hands. So we have always a balance. to see to it that, one, society, community, and victims of offenses are safe, but at the same time, even you, the suspect, you need to be safeguarded under the law, because you see, you also have a right to the protection of the law. But when we apply these protections, most of the time people misunderstand them to be denials and outright denials. I want to speak to the issue of what is bail and what is bond. Now, bail is the relief you are given, a pre-trial relief that you are given before a court to allow you get out of incarceration or from remand to attend to your trial when you are coming from home, when you are needed. Now, that pre-trial remedy is what we call bail. Now, oftentimes, that bail may be cash or not cash. And in most cases, when it is not cash, we refer to it as a bond, because you are binding yourself to the terms which are not cash, that when you abscond or you don't return for your trial, then those terms will be effective against you. Usually, a court will say you pay a cash bail, and cash is where then you must proceed to pay your money in the right place and the right amount that has been adjudged by the court. We have problems where people, before a court has spoken to the bail terms, already corridors are awash with rumors and conmen trying to cheat Ugandans. You see, we are telling Ugandans, if it is an issue of bail application, not until that application has had and the judicial officer has come and delivered the ruling and the terms you have clearly understood, and if you have not clearly understood them, please, you have a right to ask so that they explain them to you. We want you to avoid where conmen, third parties come in to confuse you, they extort money from you, and at the end of the day, when it comes to refunds, many people have come claiming for refunds when the records indicate it was not cash, it was a bond. Sureties mostly are bonded into a certain sum, not cash. Accused persons may be bonded or may be ordered to deposit a cash bail or any other property of value that will enable them to always return to court. Because, you see, you attach some value to something you don't want to lose simply because you are being tried. And it does not matter when this case terminates or is disposed of, whether in your favor or not in your favor, you are entitled to a refund of such terms for as long as they were cash and or property deposited into court. Don't deposit your monies or your property anywhere else other than into the court system.
So the cash for the slash property, this is bail.
That's bail.
And bond, nothing.
Bond,
no cash, no property.
Don't pay money.
What determines when someone gets a bail or when someone gets a
there are so many
bond?
factors. There are so many factors. One, I will specifically speak to this. We are living in an economy, and the courts don't operate in isolation of the same economy. Judicial officers are part of society. We know how our people, their economic status are, and one of the considerations for bail is the judicial officer must inquire into your capacity, financial means. If the court is satisfied that you do not have financial means to pay cash, the court will decide that you shall be bonded into a certain amount so that you still have your freedom, okay, or liberty to attend your court when you are out of prison. Okay. Then, of course, if the court, considering even the nature of the case as sensitive as that, we have seen cases where persons have appeared in our courts and probably they are answering to charges of fraud, and it's in terms of millions of money. You get that? And so the court, wanting to balance particularly your return to court to attend to the trial may put some of those cash terms and the amounts that the court deems judicially fit that you should deposit. Of course, we have also seen situations where, and we have already identified as emerging issues, where judicial officers tend to issue what they call harsh terms.
Right.
And we have gone back to the drawing table to go to do training for a judicial officer to appreciate the interface between economics and the rights to bail, so that the people and the courts are able to give what's reasonable and exercising that discretion correctly. But we have also said, in an event like it has happened before, should you feel that the terms set by a court are rather over and above what you can always appeal against those terms, and you ask, or even you apply for review, so that the court reconsiders what those terms were and then can look at some of those issues. What matters most here is what evidence has been put before the court, okay, to justify the grant, first of all, and on what terms and conditions. Once the court has all of those facts in place, has all of those conditions, are you a resident? Do you have a permanent place? Are you employed somewhere? Does your employment require your presences? Many of these things. You have a family man. You know, are you not a flight risk? Flight risk is these people who are granted bail. And I will tell you, if I had more time, that we have granted oftentimes bail to persons only for them to disappear. And when they fly away, fly and hide in the islands, fly and go wherever, that flight risk is one of the factors that has contributed to backlog. Because victims of these wrongs want their matters to be tried. But the accused persons have disappeared. And so we keep with the hope that they will be rearrested, having the matter on our shelves and in our system continuously, and then they end up degenerating into case backlog. In the criminal justice area, when you look at our statistics, almost 70% of the case backlog is people who are on warrant of arrest. So the exercise of this discretion when granting a bail is premised on the principle that, one, you have your right to personal liberty, but at the same time you have a matter before a court that you are required to come and attend to until it will be disposed of. Then thirdly, you are not a flight risk, or you are a flight risk. Then of course, whether you are able to pay the money if it is about money, or to deposit a certain chattel, or you are unable because of the economics, and then the court judiciary will lay the terms and conditions for you, either cash or bond.
It is the law and practice in courts,
Yes.
the courts of Uganda, that Eremie James, who is the PRO of the judiciary, is teaching us on this morning on the agenda. That's why we are looking at matters, the judiciary, to which we are all accounted or accountable to and for as long as you are a citizen of Uganda, for as long as you are functioning within the boundaries of Uganda. So let's learn. Let's unlearn, let's relearn together this Thursday morning. And I do appreciate you for being on the show and watching and following the conversation. Just share your opinion or question to 0709 602 592. Now let's look at the issue of recusal. There are those cases that of course have made it to the trends in line with recusal. For example, Uganda versus Kano Kaita Dewo. That's one that is rather recent, but we also have Bank of Uganda versus Nantale. That's 2023. Mabirizi, one of the Ugandans' favorite lawyers when it comes to trending on X and conversations therein. Mabirizi Chiwanuka versus the Attorney General. And all these cases involve recusal. So for starters, you will help us understand what the term recusal means, and how does one get recusal? Who is entitled to recusal? Why should one be recused?
Okay. First of all, I want to thank you for the context. You have brought a recusal, and then, of course, starting with, first of all, people understanding what recusal is. I don't want to complicate my listeners and viewers out there by using the legal court language, yes, or legal, those semantics. Recusal simply means that I cannot be a judge in my own cause. What does that mean? That there is a matter that has come to my attention. It has been put to my desk for trial, to handle. However, I have a conflict of interest. Now, the moment a conflict of interest is present in a matter before you, you are required to recuse yourself. Simply get out of the matter, because you shall not be a judge in your own cause. Where does the recusal, therefore, come from? Recusal comes right and is anchored in the Constitution. Article 126 of the Constitution of the Republic of Uganda clearly sets the mandate and powers of the judiciary. Judicial power is derived from the people and shall be exercised in accordance with the law, values, norms, and aspirations of the people. And in so doing, it sets directive principles that we shall not delay justice, we shall be impartial in our judgments, shall be independent, we shall give compensation, we shall give, and we shall not give regard to technicalities when we are serving the people who appear before us. Now, the aspect of independence and impartiality is what is couched in the principles and doctrine of recusal. How are you going to be independent in your decision or judgment in a case where you have an interest? You can't. How are you going to be impartial in a judgment when you had an interest in this matter? Article 28 clearly says we shall be independent in decision making and impartial. Our judicial code of conduct, when you are appointed a judicial officer, you take a judicial oath, okay, without fear or favor. But our code of conduct stipulates that you shall be independent in your judgment, but also impartial. Impartiality is key, and these are core principles of justice, and they are anchored in the aspects of natural justice. So, recusal comes in handy, but I want to give you also a short background. That as we speak today, we now have frameworks that guide recusal. Before, recusal was not properly framed. We did not have a legal framework which would guide our people who were conflicted or had reason to believe that there is apparent or actual bias, or whichever it is, in these matters. And that created a bit of friction between the bar and the bench, between the bar and the parties, okay? And that was not healthy for administration of justice. And so the judiciary, the Chief Justice, exercising his functions and roles under Article 133, one of the Constitution, came up with what we have today as the Constitution, Recusal of Judicial Officers Practice Direction of 2019. Now, these practice directions were brought in to cure an otherwise undesirable situation that was arising from the absence of frameworks to guide both the judiciary, or judicial officers, the advocates, members of the bar, and the litigating public on how do we handle recusal, or how should one respectfully ask the judicial officer in their matter to step aside and allow for another person to be given that matter to sit in judgment. And so the practice direction of 2019 came in handy to address and properly guide on how these matters should be handled. And this is the subsisting law, which every person who has a matter in court, every advocate who is appearing before a court, every judicial officer who is sitting in judgment should adhere to. So recusal enables a judicial officer to, on his own motion, because you see, when matters are allocated to us, we are given an opportunity to look through them. Okay? You look through it, you look at the parties, you look at the issues that they are litigating about, and you are able to do a self-assessment and determine within yourself that I think I am conflicted in this matter. And should you be then, it starts with you to inform the parties before even they say it that you are conflicted in this matter. You may not even need to give extreme reasons or reasons why you are getting out of it. The fact that you have chosen that you, in your mind, you know you are conflicted is just enough to give justice to these people. Otherwise, when you keep quiet yourself and then you proceed with that conflict, then you are breaching the code and the principles that Article 126 and 28 of the Constitution have brought on board when you are exercising the judicial power. Secondly, it also helped a party who, having reason to believe or facts that relate the conduct of a judicial officer, his other relations outside. We live in society. We have family, we have friends. I may not know that the matter before me, my friend is related to one of the parties. I may not know. You get a point? Because you see, our society is so much intertwined. Okay? However, a party before me may have those facts. And so Recusal Practice Direction 2019 give them an opportunity to bring this matter to them. Okay? To say, you know what, a member of your family is a relative of this other party, or a member of your family is... So there is a possibility of interference within that setup. Nevertheless, there is also where a judicial officer is guided that when a recusal is brought before you, in the first instance, you have done your self-assessment, and so you agree within yourself that yes, you are conflicted and you get out of the matter. You must give that information to the parties so that they understand why you are getting out of it. So that the matter now can go to the next judicial officer for reallocation. Number two, if you are not, then you will proceed. But as you are not conflicted within your self-assessment, a party, as you are proceeding with the matter, comes with those facts. Those facts must be put to you, either in writing or orally in court, to allow a judicial officer to respond to them. Now, the response may be in agreement with the party raising the objections, asking for recusal, or you may, if you are satisfied, remember you took a judicial oath without fear or favor, and you believe you are impartial, you are independent, you are not conflicted in any way. It gives you this framework where you can say, no, I am not conflicted in any way, I do not know X, I do not know Y, or whichever case you might have the facts before you. And the law tells you who is listening to me and who is seeing me on the screens, that if a judicial officer then rejects an application for recusal, he will give reasons on record, okay, and will proceed with the case to its logical conclusion. Should you still have reservations as to his continued hearing or sitting in judgment in the matter, you are allowed to put your further issues on record, but proceed to the conclusion of the case. Why has this been brought out for people to understand? It's because the judiciary was bedeviled with so many applications for recusal, and the absence of this framework to guide on how we are going to do led to the amassing case backlog, because judicial officers would get out of matters and then they are placed wherever they are. Remember, we were even fewer at the time. We are lucky to His Excellency the President, who has continuously been appointing judicial officers at the level of judges and justices, but also Judicial Service Commission, which has given us the numerous magistrates and chief magistrates and registrars. But that time, we had fewer of them, that if a judicial officer recused himself from one case, it then had to be put on the shelf and start hunting for the next judicial officer, who will then equally come and handle it. But where is the problem? Even the second judicial officer, for one reason or another, it may be even a relative, you know, of the other. Then, of course, the continuous practice and the habit, because we had the people who knew that recusal is the only vehicle for which they will use to frustrate the trial.
Right.
And I will tell you, recusal is one of the most unfortunate practices which is causing delays in our courts. Therefore, when we have a legal framework, a practice direction to guide, it is deliberate such that we don't go back into that history where matters upon recusal are simply piled and there is no other person. First of all, we must have a willing party who is going to take it off. The next judicial officer who is allocated may even have even worse, more interests in the what? In the matter. And you know, a judicial officer will not be forced to handle a matter for as long as they think they will not be impartial. They will not be independent. Now, to find a judicial officer during the time when we were very few was so hard. So we ended up with backlogs, and when we reviewed those matters, it is because of recusal. Ugandans blame judicial officers and the judiciary for riding backlog, but they don't know that their own conduct contributes to it. Now, today, we are having a lot of misunderstandings about the concept of recusal because people do not understand why we have a legal framework that says if you have raised your application and the judicial officer has recused himself, the matter will go for reallocation. Where he has listened and he has also given his reasons, okay, and does not recuse himself, the matter should proceed. Why must the matter proceed? Because we must accord you a timely decision.
Also, that means that one can recuse themselves even midway.
For as long as that application for recusal comes and has a set of facts, not the ones already ruled on, he can recuse himself at a later stage, if the facts are correct, as far as his assessment is concerned. But if he are still not, however much you make 1,000 applications for recusal, the court has already made its finding on that matter. And we are saying the legal framework to guide us in the trial, you see, it's a case management issue. It's a case management matter. How many recusals must you make until you get justice? The judicial officer has rightly listened to you and has rightly made a ruling. I am not biased. I am not impartial. I'm not partial. I am what? I am here. I took a judicial oath. That is enough comfort for you. So that if you still think you have reservations on that, let your reservations go on record. When they go on record, you allow for the trial to continue so that you are accorded a timely decision. And if you are dissatisfied, the law allows you to raise recusal, first of all, as your first ground. You see? But do you know that many people have also raised recusal? Judges and judicial officers have refused that request for recusal and have actually gone ahead to listen to the matters. Have given judgment, and amazingly, the very people who were recusing, who are applying for recusal, are the people who have won the cases. Now the question is, some of those success stories are not published anywhere. You see, nobody wants to talk about a case where a judicial officer actually rejected the recusal and went ahead to hear the matter on merit because he took a judicial oath to administer justice to all manner of people without fear or favor. And he rendered his decision regardless of that earlier want of trust in favor of the very person. We want some of you to come back and give testimony so that the public can hear and learn that recusal is not an end in itself. It is simply an assurance when a judge says, I have no problem, I'm not even influenced by some of those, whatever you call it, I am here to give you justice in accordance to Article 126.
Well, as they say, no news is good news. So
I know.
Now, allow me get into some of the comments that are coming from our viewer.
Yes,
and I must say it's an avalanche of comments. I
agree.
I hope time allows us that you are able to speak into each one of them.
Yes.
The first one comes through from Phillips, who is from Karamoja. Good morning, Julie and Council James. I'm Phillips from Karamoja. Does our judiciary really protect the people and the Constitution? That is number one. Number two, in the training of lawyers in their law schools, are they trained to write judgment or to follow what significant others tell them? Number three, I hear of this word, framing people for doing wrong when actually he or she is not doing, when actually he or she is doing right. What is it about, please? If someone is telling the truth, like corruption, illegalities, or doing wrong instead of good, why should one be framed? Number four, in my community, a family destroyed another family's home because they wanted them to leave that home, that it was sitting on their land. The case was reported to police, culprits arrested. They were remanded in a nearby prison here in Karamoja, while plans were on to have them produced in court. From nowhere, the culprits were released. The file disappeared. When the complainants went to police, the complainants, I believe, went to police to seek for reasons why this was so, they were told to come the following day up to today. What do you think could explain this, or what do you suggest could explain this? Council James, just help me here. If you are arrested and remanded in prison without a wrongdoing, what would you do and how would you feel?
First and foremost, we have different institutions with different mandates. The mandate to prosecuting in Uganda is for the Office of the Director of Public Prosecutions. They work with the police, CID, who investigate matters. Now, originally the police had their prosecuting organs, but later on, with the coming into force of the 1995 Constitution, the Office of Director of Public Prosecution was brought in to bridge that gap where matters preferred by police had to then go to the Office of the Director of Public Prosecution. In all of these districts, there are those offices of resident state attorneys who look through and advise the police on investigations and matters that should go to court. They actually now use what we call the investigation-led prosecution, something like that. Now, where a person has been arrested, the state attorney has to go through the file to establish whether there is a case. But should they think there is a case, then the matter comes to court. When they come to court, we have not participated in all the prior actions. We have not. Ours is an independent and impartial institution to administer justice in accordance with the law. And so when you come to the court, that's why the law on bail comes into play, because we administer law, isn't it? And the norms and the values and aspirations of the people. No one would aspire to be remanded in prison endlessly when they can come home and prove their case and prove their innocence, or be proved guilty, and then they can now be sentenced to whichever decision it is. So the judiciary, I said from my preamble that we are protectors of freedoms and liberties of people. So when you come, your right to liberty is given to you when you apply for bail. So anyone who went through court and they were released on bail or bond, that is in accordance with the law. So he should not have any problem with that. What is then remaining is the protection of all citizens, all people in Uganda under the law. Everybody is equal before the law. You understand that? The accused has rights, okay? And these rights are according to him under our national laws and even international frameworks, okay? So the courts have to protect the people, both the victims of the wrongs, but also with the people in conflict with the law. And those frameworks are there to guide that. But he talks about whether we are trained to only write judgments and follow other things. No, we must give a decision at every trial. A decision at every trial is what we call judgment. And this judgment is premised on the law, the facts and the evidence. The law of evidence is very clear. What can be admissible in court, all right? And that's what we follow, and then give a decision, which is called a judgment. What we are doing today is to ensure that we train our judicial officers to understand that they speak to the public, they don't speak to themselves. What are we doing? In training on judgment writing, we are emphasizing that the language should be language that will be understood by the person who is receiving that decision. Okay, so that people don't misunderstand. And Philip could be one of those who do not understand the language which we use in our judgments. But that's a training need which we have already taken on, and many of our judicial officers are now doing a very wonderful job, because they know and now appreciate that they speak to the public, they don't speak to themselves, or we don't speak to the lawyers. The lawyers know the law and this linguistic whatever, but the Jews. But the public, the litigant, does not know, is a peasant. So we need to tone down our language to suit the principles of communication, so that we are able to communicate effectively. Framing, I can't speak to the word of framing because I don't know who frames who, but the office of the director, public prosecution, the state attorneys are there to ensure that this kind of thing does not happen. Right. And even if you went through and were brought to court, the court will look at the evidence. And if you were framed, the court should be able to see that you were framed, and you will be acquitted. Your matter will be dismissed against you. Truth on wrongs, yes, we want the truth. Everyone who speaks the truth is the reason you should come to court wherever there is a matter that you know and you have facts about it. We call witnesses many times in many cases and they don't come. At the end of the day, a matter is either lost or dismissed, and then people misunderstand that decision. Those who had the facts, who knew the truth, did not come to give the truth. You understand? Those who came with whatever. So anyone who has facts about a particular matter and you are called upon to come, you are part of the administration of justice. Right. You can come and participate effectively. Destruction of property, remanded. I think, of course, destroying anybody's property is a crime, which the police, we always want to come and investigate if you made that report. And then, of course, decisions will be taken. So that's the legal regime. The administration of justice. Those people who misunderstand and say there is no administration of justice, no. Ask yourself, what is my role and how far have I played my role in this whole administration of justice?
Good morning, Uganda. I'm Emmanuel from Tinda. Are there some cases that don't have the capacity in the vicinity of bail and bond, for example, cases of treason? That is one. And good morning, I'm Solomon from Gulu. Thank you for the program, which is very important. I'd like to know whether the money is refunded, and if so, when and how. You can speak into those two for now.
First of all, I want to inform our viewers that when you are speaking to bail, you are talking about criminal cases. We have no bail in civil matters, okay? So every criminal case brought before every court or any court, if it's a capital case, the first day you appear before a magistrate's court for arraignment or informing you of the charges, the court will even tell you that they do not have the powers to entertain the matter, but they will advise you if you so wish to apply for bail in the High Court, which has jurisdiction to try your matter. If it is a matter tried by magistrates' courts, that right is told to you. So all criminal cases, regardless, you have a right to apply for bail. Bail money, if it has been ordered a deposit for cash, even if it is a chattel or property deposited into court, when the case is disposed of, whether you are guilty or you have been acquitted, the said property, money or chattel is refunded to you. Upon application, we have set service delivery standards. Within 14 days, you should expect that once we have received your request for the refund or return of such property, it should be processed as fast as it should, and within 14 days, service delivery standard, you should have your bail money back. The challenge we have had is enormous. Many people, their biodata is in conflict with what the record has. Some have lost documents, so we have to assist them in making affidavits. Some don't have, so a lot of issues are in there. Some have given us wrong account numbers. So the money is sent and it is in suspense account. It bounces. So until we again get back into, so some of those challenges in the bail refund processes contribute to a bit of delay. But your money is refundable. If it's property deposited into court, you are expected to have back your property, because the case for the agreement for which you deposited this property has terminated. We have closed it. We have finished it. And that was the contract. I shall be returning to court every when you need me until the disposal of the matter. I have done so, so I should be given my property back, and that's the position.
Now, our time is really fast spent. I really do look forward to having you back.
No, I should come back and
please.
I should come if it is possible every day, and please increase the time.
Please, we need you back.
I need to come back and talk to the public about our Judiciary Strategic Investment Plan 6, which is informed by the National Development Plan 5. Because you see, we have a lot of things we have come up with as a judiciary, which are all intended to improving and enhancing access to justice. But the public may not know, and yet we want their participation.
All right. I hope that next week we are able to have you back, because even the questions are really, really many, but time is such.
I hope my viewers have taken home a very important message today.
Yes.
Let us stop the blame game. Let us understand what the law, the values, the norms, and our aspirations are. As a judiciary, we are committed to ensuring that we play our part. Please play your part too.
Wow. I take that indeed as a parting shot. Please play your part too. And I think the simplest way to start in line with playing our parts is using the internet. We have our gadgets in our hands. Let's educate ourselves. What does the law in Uganda say about ABC? Have the facts right and start thinking from the perspective of facts tabled right in front of you, as opposed to emotions or anyone who's spreading any form of propaganda, pushing it down your throat and nudging your emotions to the wrong direction. Now, the conversation ends here. Looking forward to having Eremie James, who is the PRO of the judiciary, back to speak with us and educate us as he teaches us to learn and relearn a lot of things regarding the judiciary. As we close this, we also have a birthday to celebrate. Our floor producer, who is our boss on set here, Davis Kamukama, is celebrating his birthday. Man, I do celebrate you. You're such an amazing human being. May God bless you.
Happy birthday.
Yes. Happy birthday, Davis. And if you're to ask me what gift I have for you, I'll chew on a in-person gift, a physical gift to give you, but one that I really, really wish for you. I'll say it here on air so that you keep the record for yourself. I hope you get to enjoy Jesus Christ as your Lord and Savior.
I thought you were talking of money.
That's why I said the physical gift, I'm chewing on it. I'm just definitely going to give it to him. But the best gift I wish for him is that I've put across. Happy birthday, Davis. We really, really do cherish you. You're an amazing human being. It's fun working with you. It's fun conflicting with you as we build the program, but it's all good, and we do celebrate you. Cheers. Enjoy your day. May you grow wiser and more impacting to the nation of Uganda. Happy birthday.
It's so conflicting.
Yes. Always, 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 always. For as long as you...
Live from UBC Studios in Kampala, this is Good Morning Uganda.